Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Before going on to the topic, it is our regular practice to recite the preamble of the Constitution of India with a strong faith in the preamble that that is our goal and that is our soul, because entire constitution, their goal are enshrined in the preamble, and it is one of the fundamental duties guaranteed under article 51A, which says that, which prescribes the fundamental duties on our part to remember our forefathers, and we have to try our best to realize their goals enshrined in the preamble. Therefore, only when we recite, it will get registered in our mind. Once it is registered in our mind, we can put it in practice. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So now, lecture number 45. I welcome each one of you to our lecture number 45. So what is the topic and where we have in which question paper it has appeared? First, let us see that, dear friends. December 2022, section number 3, question number 3, it carried 10 marks. What is the question? Whether power of contempt of an advocate by High Court and disciplinary proceedings by Bar Council can coexist. Discuss with reference to judgments. So meaning thereby, if an advocate commits a contempt proceedings can be initiated by the court. Whether the disciplinary proceedings can also be initiated by the Bar Council. Whether contempt power vested with the court and disciplinary proceedings vested with the Bar Council, whether they coexist or not. That is the question. So now let us understand, dear friends, when a contempt is committed. Thereafter, what is with reference to the disciplinary proceedings? So for this purpose, I will take you to these certain relevant provisions. Firstly, we will be seeing Article 129 of the Constitution of India. Similar power vested with the High Court, Article 215. Thereafter, Article 142 of the Constitution of India. Then, Contempt of Courts Act, Advocates Act. Then how everything is interpreted by the Honorable Supreme Court. First and foremost is Article 129, which talks about the Supreme Court is a court of record and has power to punish for contempt. So contempt power comes from the constitutional power. Constitutional provision itself provides for the punishing for the contempt. Article 142, inherent power. The Honorable Supreme Court may pass any orders to do complete justice. And here the relevant provision is Article 142 Clause 2. That also I will take you there. Then contempt of court. Why there should be a contempt of court? As we have already discussed in the previous occasions, the preamble provides us liberty of thought, expression, belief, faith and worship. So whatever you have a liberty to think, liberty to express. Further, this is a fundamental right guaranteed under Article 19 Clause 1A, which gives us a right to speak and express. But is it an absolute right, or does it subject to reasonable restrictions? 19 Clause 2 says that you cannot speak against the sovereignty and integrity of India. You cannot speak against the morality, decency, and you cannot commit contempt. So that is all the restrictions and much more. So when we are speaking in the court of law, as an advocate, you are representing on behalf of the client. Dear friends, this is very important. Please come. So in the court of law, we are not standing there in the capacity of Dr. Saravanaraja or not in the personal capacity. We are standing there on behalf of our client. Client has authorized us to represent his grievance and then put forth before the court. So therefore, dear friends, whatever you are speaking, the court will ask. The court might know your name very well, but still they will put a question even to the well-known seniors, who are you? Then you cannot say, I am so and so, my lords. You should say for whom you are appearing for. And that is how we say we are for the de facto complainant. We are for the accused. I am for the accused, my lords. I have 3 children. I am the sole breadwinner of the family. That is how we project. So there we are representing our clients. Therefore, we should be very, very cautious in our words, usage of words before the court of law. Because whatever we are expecting a favorable order. We are expecting that justice is to be done in your case. Therefore, you cannot antagonize a judge. You cannot go against. But at times when there are inconvenient questions which may go against your case, when it is put forth by the honorable court, you should politely say, my lords, there is yet another possibility. My lords, there are certain material facts. I would like your lordships to come to this particular page, so and so. Otherwise, it will cause gross miscarriage of justice. Please hear me, my lords. Please bear with me. So, in this respectable manner, in this polite language, and body language is also important, dear friends. You don't think that you can make only the lip service. You may think something else in your mind. But whatever you think, face is the index of the mind. And your body language, how you are projecting yourself. In one case, dear friends, this is good that I will inform our friends. You all know that one of the legendary advocate, senior advocate, Mr. K.K. Venugopal, he was a former Attorney General for India. His father, whose portrait is here, M.K. Nambiar, a constitutional lawyer. I was present in the court and it was the matter was listed before Honorable Justice Markandeya Kodjuji in another combination of another judge. When Mr. Senior Advocate K.K. Venugopal sir appeared and notice was issued, a notice was issued in his favor. Thereafter, when he was about to leave, when Mr. K.K. Venugopal sir was about to leave the court, another matter was going on, but still Honorable Justice Markandeya Kodjuji had called Mr. Venugopal, come here. Then he immediately rushed again to the podium. Then, my lords, then Justice Kodju has said, today you got a favorable order, is it not? Notice was issued in your case. Yes, my lords. Yes, my lords. But after getting a favorable order, you did not bow your head before this court. My lords, I did it, but I will do 10 times before this court. In this event, what is reflecting is Mr. Senior Advocate Venugopal sir's age is much elder than the honorable judges, but that is the institution. So when we are bowing before the institution, a temple of justice, therefore he bowed down many times and he said, my lords, may I leave now. So this is how, dear friends, you may be a senior advocate, you may be a legal luminary, but we are before the court of law. So we have to be, our body language, our usage of language must be very, very cautious, and it should be coined. See, we may have 10 points in our favor, but what should be the best point? That should be your first point. Because once you miss the bus, you are not aggrieved, but your party is aggrieved. So therefore, when we are before the court of law, the words used to be very cautious and respectable manner, in a dignified manner, because to uphold the majesty of law. So when you are crossing your limits, when you are making scandalous allegations against the judge, then you are crossing the Lakshman Rekha. You are exceeding your limits. Then what is the outcome? That is the contempt of court. They can punish us. So therefore, only in order to uphold the institution, majesty of justice, contempt of court is sparingly used by the honorable judges. This is with respect to the contempt of court is concerned. So you should obey the orders passed by the court. Willful disobedience amounts to civil contempt. If you are going to make any scandalous allegations against a judge, amount to a criminal contempt. And very recently we had seen Prashant Bhushan sir's case also, where the message, tweet, was considered as a guilty of criminal contempt. So now moving on to the professional ethics that is provided under the Advocates Act. And section 35 of the Advocates Act prescribes punishments also. It depends upon what he does, the punishment flows. Maybe advocate may be reprimanded, warning, don't do this again, you are warned. Number 2, he can be suspended also, maybe for 3 months, maybe for 3 years also. Number 3, he may be removed from the role itself. He will be ceased to be an advocate. He will be disqualified as an advocate. So this is power. These powers vested with the disciplinary proceedings of the concerned bar council, not with the court. Thereafter, what sort of punishments we have seen, for what sort of act that you invite those punishments? When you are guilty of the professional misconduct. So first you should know what is professional conduct, how do you conduct yourself. Only when there is a violation you are committing professional misconduct. So there are ethical standards provided under the Bar Council of Rules, India rules. Duty towards the court, duty towards the client, duty towards your colleagues, duty towards your society. because advocates shall remain as advocate at all times. It's not only within the vicinity or before only the court. An advocate at all times, an advocate. He is a privileged member of the community, of the society. What is moral and what is legal for common man may not be lawful or moral for the lawyers. Because when you are saying it is a privilege, it comes with responsibility. So when you are claiming that you are a privileged community, you should act both in letter and spirit that you are not crossing the limits and you are leading the society. Honorable Justice Krishna Iyer, my Lord, has said, whatever the Bar Council of India rules, Advocates Act, whatever it is stated, but it should not remain in the paper book. It should remain in your heart. That is most important. You will be a guiding light to yourself. You don't require a guiding light from the rule book. You be a living rule book. So that is how, when you go against the rules, duties, then you are committing, you are found guilty of the professional misconduct. Therefore, you are punished under Section 35 of the Advocates Act 1961, dear friends. Now we are coming to the question. What is the question? Whether contempt committed by an advocate and the professional misconduct, whether disciplinary proceedings can be initiated against such an advocate, whether such powers are coexisting. The answer is yes. With reference to which judgment? There is a judgment, dear friends, very important judgment. You should never forget, because we are part of this judgment. SCBA, Supreme Court Bar Association, has filed this. Supreme Court Bar Association versus Union of India and another. So when you get this question, please do write this judgment. Easy to remember also. Supreme Court Bar Association versus Union of India. Before a constitution bench judgment. This is a constitution bench judgment. It is reported in AAR 1998, Supreme Court 1895. AAR 1998, Supreme Court, page number 1895. The honorable judges are S.C. Agarwal, Honorable Justice G.N. Ray, Honorable Justice Dr. A.S. Anand, Honorable Justice S.P. Barucha, and Honorable Justice S. Rajendra Babu. In this case, what happened? A very important case was overruled in this case, dear friends. That is Vinay Chandra Mishra. So what was the issue before this court? How the matter came up before the constitution bench? Before the constitution bench, there was one reported judgment, that is 1995, volume 2 ACC, page number 584. The name of the case is Indri Vinay Chandra Mishra. The Honorable Supreme Court found the contemptor, an advocate, he was an advocate, guilty of committing criminal contempt of court for having interfered with and obstructing the course of justice by trying to threaten, overawe and overbear the court by using insulting, disrespectful and threatening language. While awarding punishment, keeping in view of the gravity of the contumacious conduct of the contemptor, the court pronounced these orders by invoking Article 129, read with Article 142. What was the order passed? The facts and circumstances of the present case justify our invoking the power under Article 129 read with Article 142. See how two articles are read together, dear friends, to award to the contemptor a suspended sentence of imprisonment. So they are imposing a imprisonment, the honorable court itself suspending it. Suspended sentence of imprisonment together with suspension of his practice as an advocate in the manner directed herein. We accordingly sentence the contemptor for his conviction of the offence of criminal contempt as under. Now, what is the sentence that they are narrating here? The contemptor Vinay Chandra Mishra is hereby sentenced to undergo simple imprisonment for a period of 6 weeks. However, in the circumstances of the case, the sentence will remain suspended for 4 years. So they are sentencing him for 6 weeks, but that is suspended for 4 years and may be activated in case the contemptor is convicted for any other offence of contempt of court within the said period. So he was found guilty. The sentence is 6 weeks imprisonment, but that is suspended for 4 years. That means keeping him under complete intense care and seeing that whether does he commit any other contempt or not. So to bring him within the Lakshman Rekha. If he commits contempt, definitely he will be going to jail for 6 weeks. Otherwise, it will be suspended. This is one punishment was imposed by the Honorable Supreme Court. Next, the contemptor shall stand suspended. This is very important, dear friends. The contemptor shall stand suspended from practicing as an advocate for a period of 3 years from today, with the consequence that all elective and nominated office posts at present held by him in his capacity as an advocate shall stand vacated by him forthwith. So now the question arises whether the Honorable Supreme Court, by virtue of Article 129 read with Article 142, can they suspend an advocate from practice for a period of 3 years? Or suspension, reprimanding or removal lies only exclusively with the disciplinary committee of the Bar Council. If that is the case, then what the Honorable Supreme Court has suspended him from practice, that is incorrect. So this was the judgment pronounced in Vinay Chandra Mishra case. Now our Honorary Secretary of SCBA had preferred a writ petition before the Honorable Supreme Court for reconsideration. That is how the matter came up before the 5 judges bench, because this affects everyone. It affects the entire. See, there is an Advocates Act where they provide for a summary in nature, disciplinary proceedings are summary in nature. They were heard, then they pass the orders, and then appeal goes to the Bar Council of India. From there it goes to the Supreme Court. But in the appeal, when it Honorable Supreme Court hears under statutory appeal, that is different. When the same Supreme Court hears under the contempt, it is different. Hope it is clear, dear friends. So the way is different. One is Contempt of Courts Act. The Honorable Supreme Court do not have power to suspend any lawyers. They can recommend. See, this person is found to be guilty of criminal contempt. Therefore, we recommend the disciplinary actions to initiate action. They cannot dictate, the Supreme Court or the High Court cannot dictate the disciplinary proceedings, what decision is to be taken. It is an independent body. So they may recommend for initiation of action, but outcome of the disciplinary action is vested with the disciplinary committee only. So therefore, in Mishra's case, that was overruled in this judgment. So in this judgment, the Honorable Supreme Court had elaborately dealt with Article 129. Why it is a court of record? And Article 142 we have read in many cases. To chase injustice, sky is the limit. That is also the Honorable Supreme Court has held. But in this case, the Honorable Supreme Court has held Article 142. It has to be exercised sparingly and it cannot exceed or encroach upon the autonomous body or a statutory body. That is wrong. So 142 will not apply here. Then they have distinguished what is the contempt of the court, what are their powers, and Advocates Act, and ultimately what is the conclusion, dear friends. Let me read, and I request each one of you to read at your convenient time. In a given case, it may be possible for this court or the High Court. Dear friends, the question is High Court. So it applies to the Supreme Court also as well as to the High Court also. In a given case, it may be possible for this court or the High Court to prevent contemnor to appear before it till he purges himself of the contempt. But that is much different from suspending or revoking his license or debarring him to practice as an advocate. Dear friends, this is very important for AOR examination because they have referred in a case of contumacious, unbecoming or blameworthy conduct of an advocate on record. This court possesses jurisdiction. See, the Honorable Supreme Court has held in this case, SCBA case, that we do not have power to suspend the practicing advocate. That lies within the domain of the Bar Council of India, Bar Council of concerned state. What about advocate on record? Advocate on record examination exclusively conducted by the Supreme Court. Supreme Court confers that he is an eligible candidate to become an AOR. And who has an authority to suspend that AOR? It lies with the Supreme Court and not with the disciplinary committee of any bar councils. So the examiners might ask, what is the position with respect to the AOR is concerned? AOR is concerned, they can suspend. They may suspend for months also, that AOR, so and so AOR is suspended for 1 month, 2 months for his misconduct. Or they may even remove from his role as an AOR. So an advocate on record, this court possesses jurisdiction under the Supreme Court rules itself to withdraw his privilege. See how beautiful terms, dear friends. It is a privilege to practice before the Honorable Supreme Court. It is not all lawyers, those who have enrolled, does not get an opportunity to enter the Supreme Court. I have seen few lawyers to say, at least once in a lifetime, let me just touch the ground of the Supreme Court, let me worship the temple of justice. Now there are few interns, even in their college curriculum, they come here and they practice, they see how the court proceedings are going on. So it is a privilege to practice before the Honorable Supreme Court. And the power to grant the privilege, see how beautiful interpretation. Power to grant the privilege includes the power to revoke or suspend it. So we have the power to confer you the privilege. At the same time, we have the power to revoke also or suspend also. The withdrawal of that privilege, however, does not amount to suspending or revoking his license to practice as an advocate in other courts or tribunals, dear friends. So ultimately, so they have discussed everything, and upon the basis of what we have said above, we answer the questions posed in the earlier part of the order in negative. The writ petition succeeds and is ordered accordingly. My lords, before, see, whenever we address before the court, of course, my lords only, in future lords are always there. So therefore, dear friends, whenever we address before the court, my lords is to be used and respectful language is to be used, and we should never exceed our limit. Reason is, we are part of the system. We have to respect this system. And this is how we address the answer to this given question, dear friends. Thank you so much for your patience hearing. Please join us for group photo.